Well, we're going to get started. It's about 9 o'clock. And we're fortunate to have a small, intimate setting like we were hoping for. So, I think this setting lends itself to dialogue and asking questions as we go. So, we can be informal, and if you have a question along the way, don't hesitate to speak up. I think that, well, just by way of background, I'm an employment attorney. I've been doing labor and employment law for businesses and organizations for 11 years. And I tell people that a lot of HR work, a lot of employment law compliance is common sense. In 2012, it's just common knowledge that you can't discriminate against people because of certain reasons. I had a case a couple years ago where an HR manager was asked, how did you know that you were not allowed to refuse to hire this man because he's African American? She really didn't have a good answer for that, but she said, just common knowledge, everyone knows that. Well, everyone does know that. And a lot of HR work is, common sense, but a lot of it's not. And today we're going to be focusing on the stuff that's not common sense, and in fact, really flies in the face of common sense. So some of the things I'm going to be telling you today, you might have the reaction of, that can't be right. But I think that's why what we're going to be talking about today is in my opinion, one of the two hot topics in employment law these days. We're going to be talking about social media use in three different settings. Can you and should you control employees' social media use during the day? The main thing we're going to be talking about is the second thing, employees' rights to complain and discuss conditions of work, even if they do it on social media, which is a very public setting. And the third thing is using social media in recruiting and hiring. What can you do, and recommendations of what you should and should not do. So as I said, the first presentation goal: help determine how you should limit employees' social media use at work during the day. Is it going to be productive, or is it going to be a waste of their time? Second, ensure your policies and procedures on social media fit your business needs and comply with the National Labor Relations Act. Don't glaze over because I said the L word, labor, because you're not a union shop. The National Labor Relations Act applies to all companies and all organizations, except for very small ones, whether you have unions or not. And we'll talk about that a little bit more detail in a little bit. And third, understand the risks and benefits of using social media to screen job applicants during the recruiting process. So first of all, just by way of foundation, what do I mean by social media? Well, there are all the logos that, by now we pretty much know what they mean, just, by way of logo. LinkedIn, blogging, Google+, Facebook, of course, is the big one. And, in 2012 and leading up to 2012, this is how a lot of people communicate socially. This is their primary social outlet. And there's a heavy reliance on this. It's easy to get sucked into this world, and a lot of people have delightfully been sucked into it, and so they use it a lot, and they want to use it during the day. They want to use it for both personal and business reasons. But how does that affect you as a business owner or an HR manager? Well, the first question is talking about the first of our three topics. Can you limit and control employees' use of social media? Well, the answer is yes, you can. They were hired to do a job. Frankly, a lot of organizations these days have a full-time social media manager. So some people were hired to do social media. Now that doesn't mean they were hired to be on their personal Facebook page. They were hired to use social media for marketing reasons for the organization. I think my recommendation would be don't have a blanket policy in this regard. Obviously, to use an extreme example, you don't want to have a blanket policy of no social media use during the day, because then what's the social media manager going to do? But I think that some organizations realize the temptation of employees to use social media for social reasons, and they have a knee-jerk reaction of just completely banning it. And maybe they'll even have their IT department, put a block on social media sites. Well, I don't think that's a good idea to have that blanket policy, because a lot of jobs lend themselves to networking and marketing, and this is a good way to maintain your network, not just over the phone, not just by email, not just in person, but on LinkedIn, Facebook, and these other sites. So, I asked the question, is blocking all social media the answer? Well, I think the question that raises is, what type of job does the employee have? In a big company, does the person work as an internal accountant or as an outside salesperson? Well, if he or she's working as an internal accountant, there's going to be much less of a need, probably no need, frankly, to be connected and have a marketing network on behalf of the organization. Whereas if the person's a salesperson and their job is to generate sales, well, it's probably a good idea to encourage that person to be active on social media. So, the question is to ask her, does the employee's job require him or her to maintain a network inside or outside the organization? So, one of the maxims of HR work is to treat employees consistently. And I don't think this violates that maxim, because you want to treat employees consistently who are similarly situated. Well, employees are not going to be similarly situated if one's, has the need to be making external sales versus, just doing internal administrative work. For the folks, if you do tell them, no social media use during the day, at least while you're on the clock, you watch out for them accessing it through their iPhones anyway. These days with the 3G and 4G systems, they don't need to be able to log onto your wireless system to get on. So be wary of that. As far as the content of what they're posting and what they're talking about, can you regulate the content of what your employees are posting? And the answer is yes, with exceptions, and with one big type of exception that we'll be talking about under the National Labor Relations Act. But yes, you can regulate content. I asked there, what about First Amendment rights? Well, I think everyone here is a private organization. No one here works for a government agency, and therefore employees in their capacity as employees of your organization don't have First Amendment rights. That is to say, as citizens of the country, of course, they have First Amendment rights, and the government can't come in and say, we don't like that you criticize the Senate or criticize the IRS or the president or whoever, and we're demanding you take that down or we're going to arrest you. Obviously, that would violate their First Amendment rights. But you, as their supervisor or HR manager, can very well tell them what you said is not consistent with the branding and image of the company, and we don't want you to say those sorts of things. Subject, again, as I said, to what we'll be talking about concerning the National Labor Relations Act. So let's get into that second category, and we're going to be talking about concerted activity. And the first question to ask here is, can you discipline employees for criticizing the company on social media? Criticizing the company, whether it be criticizing the company's business decisions, strategic decisions, marketing decisions, as well as internal conditions of work, criticizing their own manager, criticizing how they're paid, criticizing HR managers, whatever. The answer is yes, but be careful, because it depends exactly what they're criticizing. The National Labor Relations Act, as I said, applies to all private sector employers, except for very small ones. So let's assume that it applies to your organization. And what the National Labor Relations Act says is that employers in the private sector are limited in certain ways in responding to employees who engage in concerted activity. And that could cover everything from joining a labor union, forming a labor union, making collective bargaining decisions in a labor union, as well as, before you even get to a formal union context. It protects collective concerted activity. It applies to employers without unions, and I need to say too, this is not a new law. This law is from the 30s. So this law is over 75 years old. The reason it's such a hot topic now, and the reason it's no longer some obscure law, frankly, I think is because of social media. Because if employees wanted to criticize their conditions of work 15, 20 years ago, 50 years ago, 75 years ago, how would they do it? Well, they do it at a bar after work with 2 or 3 of them talking in person. Well, that's going to be private. It's all going to be in-person conversations, maybe over the phone, maybe in person. And so once it's said, it's gone. There's no record of it. It doesn't live forever. Well, now with social media, a couple things. First of all, it's in print, so it's there, let's say forever. And it's public too, because you're not just connected with your coworkers on your Facebook site, you're connected with a few dozen or a few hundred of your closest friends, some of whom might be coworkers. Well, the National Labor Relations Act says that if you criticize the company in print, in a very public setting, on your Facebook page, that does not lose the protection of the act. So before, 2 people on the car ride home complaining about wages or complaining about their manager, that was a pretty private setting, pretty low risk for the employer getting a black eye because of that. Now if they have that same conversation on Facebook for 800 people to see, it has the same protection, but now the employer is at risk for some bad PR. Well, that's why this is such a hot topic these days, because employers' reactions is to jump on that. I mean, frankly, I think common sense, just a natural instinct, is to go after that and discipline the person for that, tell them not to do that, tell them to remove it, because they're giving the company a bad image. And that's what you can't do as long as the speech is protected as concerted activity.